This program is brought to you by the Illinois State Bar Association. All copyrights are owned by the ISBA. Please note that after you have finished all the videos in this program, you must complete the certification process to receive MCLE credit. Just complete the program evaluation, certify, and save your MCLE certificate of attendance.
Welcome. I'm Alan Kaplan, CLE Coordinator for the Labor and Employment Section Council of the Illinois State Bar Association. This is the first of a two-part program we've put together on the procedures of the NLRB. Today's program will be on representation, election, procedures, and in December, our next program will be on unfair labor practices. Please join us for the program in December. And please look at both of these programs. There's also very good materials, course materials that we have prepared and that are part of the program. Here's the challenge. I'm at my desk, I represent management. I'm at my desk, it's 4:45 on a Friday afternoon, getting ready to finish my brief to the appellate court, and the phone rings. It's the president of HSK Inc., and he is angry. He's just been called by a field examiner at the National Labor Relations Board in Chicago. The Teamsters Union has filed a petition for an election. He's angry. A union at his company? How can this be possible? He screams into the phone. What do we do? He needs immediate answers. My focus as a lawyer must shift immediately. I know that almost within 8 days, there's going to be a hearing, and it's going to go ahead whether I like it or not. I know that there will probably be an election within several weeks, whether the company likes it or not. There's no way really of stopping this train. I know that my life and the life of my client will change dramatically over the next couple of weeks. And we've already lost 2-3 days because the union was very smart by filing their petition on a Friday afternoon at 4:45. Therefore, we now have the weekend and we'll not be able to do too much until Monday morning. But we have to get into gear and start work immediately, Saturday and Sunday. So who are the players? The players are the government, the lawyers, and the consultant for the employer. They are here today to take us through the procedural issues, not substantive, but procedural. First up is Dan Nelson, the assistant to the regional director in Chicago Region 13, a place I had the pleasure of working at in the 1980s, the dark ages. Much has changed since then for the board, but the procedures are basically the same. And we have to keep up all the time with the changing procedures and the changing law at the National Labor Relations Board. Dan is the acting regional director at the moment and has spent his career as a government neutral enforcing the National Labor Relations Act and processing election cases. Dan, take it away.
Thanks, Alan. The story you just relayed does bring me back a little bit to one of my early days as an examiner, making that call to an employer, and they're completely blindsided, and the response was, "What are you talking about? They want a union? Who did this? I'm gonna get them." Like, slow down. You may want to talk with an attorney, and I'm sure if they talk with someone like Alan, that would have calmed them down and got them on the right track. And but I mean, that's kind of the I do find it somewhat ironic at times with representation cases. They say that this is fact-finding and non-adversarial proceedings. But whenever you have, a union, coming into an employer, it's going to be adversarial more times than not. And so, it's how to deal with that. And, here at the NLRB, we do our best to kind of work with the parties and work through the issues as diplomatically and as quickly as possible. So. But anyhow, as Alan said, I'm Dan Nelson. I'm the assistant regional director at Region 13 in Chicago, and I've been in that position for eight years or so. But been with the region for 20 years. In representation cases as ARD, it's kind of what I do, what I focus on. A lot of petitions that are coming in, and in the last 6 years, since 2015, there have been 2 changes to the rule on our cases. And so if you've had an R case more than 6 years ago or so, things have changed and actually changed a lot. So, stay tuned with, we're going to go through that. So at this point, I am going to give me a moment here to share my screen. And we can kind of get my PowerPoint going, which I believe is also in the materials. Back to the beginning. All right, so what we're talking about here is the representation case procedures. And like I said, the most recent rule change was implemented in June of 2020. And kind of give you an overview of the presentation. I mean, as Alan said, the government, that's what I'm here to do and tell you kind of the procedures. And for you guys, a lot of you, this is kind of a behind the scenes look at what happens once a petition's filed and what we're doing on the NLRB side to work with the parties and get this, because our job is to get this to an election. Let the employees express their choice in a secret ballot election. That's what our goal is. And the rule itself says to do it as soon as practicable. So that's what we try to do. But so this process is going to go through that. So we have the filing of the petition that'll cover the initial processing, stipulated election agreement, and that is, ultimately our goal, trying to get the parties to agree to move forward with an election with an appropriate bargaining unit and a date, time, and place that's suitable and agreeable by everybody. But if you can't get that stipulated election agreement, also known as a STIP, then we go to a hearing and we have to litigate. More often than not, it would be the bargaining unit, who's in and who's out. I mean, that's the key question more often than not. Then either way, through a STIP or through a hearing in which a decision would follow, that you get to an election. That election is, I still think it's one of the most amazing things that our agency does. We, government officials come out to the employer's facility with an old booth, the metal booth that we set up, and cardboard box and pieces of paper that these employees are going to check yes or no and drop it in a cardboard box, and then right after that you open it and count it. But if something goes wrong during the entire process, you have a post-election process to kind of address any issues that may have occurred that could result in either a rerun or certifying the results of the election. So filing the petition, I'm just gonna, there you go. I just want to put that all up there. So now what happens is when you file a petition, it is the obligation of the petitioner to serve a copy of that petition, as well as instructions on representation cases and blank statement of position form on the, I'm going to use an RC petition, for example, when a union files it, and the union has to file all those items on the employer prior to filing it with us. Because what ultimately they're going to have to do is file a certificate of service with us showing that they have done so, that they've served the petition, that they've served the instructions and what they needed to file with the employer. What they also need to submit with us, but they do not serve on the parties, is a showing of interest. The showing of interest is also known as union authorization card. These are the cards or the signature sheets that employees have signed indicating that they would like to be represented by that labor organization. And they need to submit to us at least 30% worth of the bargaining unit in order for us to initiate processing of the petition. As I said, I just kind of went through generally with an RC petition. The same is true with an RD petition, also known as a decertification petition, with employees then would have to serve all those documents on the employer as well as the union. And then the showing of interest would then also be filed with us. At this point, I will emphasize that e-filing through NLRB.gov is certainly the preferred means of filing, and we'd like to think that our website is pretty self-explanatory and user-friendly. So hopefully, when we have had a lot of luck, and a majority of our petitions and a lot of our charges, for that matter, also are filed through the website. So the first thing that that we're going to be sending out, and the key things to note if you're representing the employer or the union for that matter, are the dates that are involved. And this is all set by the rule, that the NLRB rules and regulations. The hearing date, working backwards here a little bit, the hearing date is the most important date, and that's the date, the 14 business days after service of petition. So that's almost 3 weeks in some cases, right? So you've got a lot of time. I mean, this is a far cry from, what it was just a year and a half ago, in which it was eight calendar days usually before the hearing. And before 2015, it was 14 calendar days. So 14 business days now is quite an extensive period of time to have, and the parties to work through any issues in election. So the statement of position due date is 8 business days after service of the petition on the parties. The statement of position date, and if I'm not mistaken, I believe in your packet of materials that has been included, there are blank copies of RC petition and RD petition, as well as some of these forms I'm referring to, the statement of position form, the responsive statement of position form. And if they're not in the packet, these are all very accessible on our website at nlrb.gov. But the statement of position due date, that it basically what they're doing here is they want the employer to identify what the issues are. And in particular, the bargaining unit is more often than not the most critical item that we want to try to focus on and try to get resolved. And so the statement of position form includes your position on the appropriateness of the petition for unit, who should be in, who should be out, and also ask for a list of employees in those classifications, who you think should be in, who you think should be out. The statement of position and ultimately the responsive statement of position do need to be served on all parties. This is not confidential. This is something that gets provided to all the parties. Because again, this is considered to be a fact-finding endeavor that, we wanted everybody to be transparent and upfront as much as possible with the facts, because we're not trying to play gotcha on anybody. We really want to, everyone to go in with their eyes wide open and know what the issues are and identify the issues so we can work through them. There can be disagreement. We may have to go to hearing, but we don't, what these SOP and RSOPs do, they kind of prevent any ambush on the hearing date if it goes to hearing. So it does kind of present the issues for everybody so they know what they're getting into going into the hearing if there is one. The responsive statement of position is due 3 days before the hearing date, and that is just kind of what it says, responds to the statement of position that, again, I'll use the RC petition for an example, that the employer files the statement of position, the union, who is the petitioner, would be filing the responsive statement of position, and either agreeing or disagreeing with what's in the statement of position. Now, during this whole process, there's a board agent that's working with all parties to try to narrow the issues, the bargaining unit, and these are just the statement of position and responsive statement of position are preserving these issues should there not ultimately be agreement on everything in which the parties are, because ultimately the goal is to get a stipulated election agreement and avoid a hearing. So these documents that are being served by the agency upon initial filing, the petition, notice of hearing, notice of petition for election to be posted by the employer, and that's I believe within 5 days. It was 2 days. I think it's now 5 days for that notice of petition of election to be posted. And the SOP and RSOP forms are also included when we serve the document. So we serve those via email and US mail. So they're, but one thing that's interesting here is that, again, with the responsibility for the petitioner to serve all the petition itself on the parties before they give it to us, it does give the other party, and like Alan was mentioning in his scenario earlier, the employer, that now has a heads up that they have gotten a copy of this petition served by the union before the board agent RB is calling, so that they're not completely taken off guard usually. Initial processing and negotiations. Like I said, stipulated election agreement is the goal. Bargaining unit and date, time, and place of election are usually the critical elements in this. I mean, there's several other things. We need to establish the legal name of the employer, need to make sure that we have jurisdiction, that there's commerce, facts that are stipulated to, the legal name of the union, and other things that are more nuanced or not really it's controversial. Payroll ending date is another one. But anyhow, the bargaining unit is the big thing. And I'm not going to go into the details, but I mean, an appropriate bargaining unit. For those of you who are not familiar with the NLRB or haven't handled a representation case, you're like, oh, an appropriate bargaining unit, that's easy enough. Well, it's a little more complicated than you may think, because there are, it's case law. Appropriate bargaining unit is, there's a lot of ways to interpret that and the way it's defined by the board, and depending on what the unit, who's in and who's out. That's what we're looking to find out. Now, when we are doing a bargaining unit, there is wiggle room for the regional director to allow disputed classifications to vote subject to challenge. And that's generally up to 20% of the bargaining unit. If there is dispute on that, about that amount or less, then there is a provision that allows those employees to vote subject to challenge and move forward with the election. And it would also, should it go to hearing over those issues, the regional director also has discretion not to allow litigation over those issues prior to the election. It might, in deferring it to after the election, if those individuals are determinative. So date, time, and place of election, that's the other big item that can be, kind of a stumbling block for some, how quick to have it, and now, this day and age, it's the type of election, whether it's a manual or mail ballot election. As you might imagine, during the pandemic, we've done quite a bit of mail ballot elections. Not actually until May of 2021 of the pandemic did we even start doing any manual elections, and even those were outdoors in tents, and they still are. We're still doing manual. There's a case out there called Aspirus Quinoa that the board sets forth, several factors to be considered for the regional director to determine whether the situation or the pandemic is such that we would need to conduct a mail ballot election. So I'm not going to get into those details, but that's out there. But anyhow, the date, time, and place of election, like I said, the rule does ask that everybody do it as soon as practicable, because the objective is to get the employees to the voting booth. Expectations, our cases are non-adversarial fact-finding proceedings, and that's kind of what I made reference to earlier. And with the parties, prompt response. We do, like I said, there could be almost up to 3 weeks between the filing and the hearing date, but the board agent, we want to get all the parties on the same page and try to resolve the issue sooner than later. We recognize that, as attorneys, you have clients that may not be as cooperative and may have a hard time, explaining situations. So for being transparent with the board agents that you're working with, what's the issue? Is it the unit, the date, or client conflicts, or some other issue that we're not aware of? And again, those SOP and RSOP forms that need to be completed, because if you do not submit those on time, there is consequences, and that could mean that you are precluded from litigating those at a hearing. So you need to file those. Actually, it's noon on the due date, noon Central Time for Chicago, but noon local time for whatever region you're working with. But there are consequences if you don't do it. So it is really important that those forms are completed and filed timely. The SOP and RSOP details discloses positions on bargaining unit and other potential issues. The employer SOP includes a list of employees. These are kind of things that I just went through. But again, these are kind of just putting everything out there so that we know what's going on. It kind of keeps the process moving. And like I said, consequences of not filing is preclusion at a hearing. Hearing, I'm not going to get into too much detail with the hearing. That's a whole nother, we could go into that. We could spend an entire session on hearings and how to go about litigating that and appropriate bargaining units and everything. But again, although appropriate unit must always be established, disputes concerning individuals' eligibility to vote or inclusion in an appropriate unit ordinarily need not be litigated. And that's what I was talking, that goes back to that 20% rule that I was referring to earlier, that if it's a small segment more often than not, that those will be able to vote subject to challenge and would not be litigated. Again, it's in the interest of getting to an election sooner than later. So the RD has discretion to defer litigation of eligibility. I'm just gonna put all these out there. At the hearing, offers of proof not required, but a hearing officer may solicit offers of proof. And those offers of proof, they need to be detailed, giving exactly what witnesses would testify to, and trying to figure out whether it's something that it should be litigated or not. You know, something, you know, more often than not, it shouldn't be a surprise based on the statement of positions and everything. And usually the parties are going in fully informed by the board agent what issues will be litigated and which ones may not be based on preclusion. So those are some of the preclusion issues that are noted there below. At the election, or prior to the election rather, for the voter lists, the employer must provide a voter list within 2 days after the stipulated election agreement or a decision after a hearing. This list must be provided directly to the parties and the region electronically if feasible. And here's some of the content to go in there: the name, work location, shifts, and this also includes contact information, which is sometimes a lot of people have concerns about, which includes employees' home addresses and cell phone numbers, for example. And if there is a list of individuals who will be voting subject to challenge, that would be on a separate list for that. Election. So ultimately, you know, after a stip or after a hearing, we've got the unit, we've got the details of the election all sorted out. So we will prepare a notice of election and send that promptly to the parties via email only now, assuming we have email addresses for everybody. And these notices must be posted for 3 full business days and also distributed electronically if that's how the employer communicates its employees. Again, this is pretty much to notify the employees when that election is going to be so that they are aware and that they can prepare accordingly. Elections, for those of you who don't know, again, like I said before, it's NLRB board agents, marching out there to the employer's premises more often than not. Sometimes a neutral location, a hotel or library or something, but more often than not, it's that in non-pandemic situations, we are going to the employer's facility and conducting the election there. Actually, before I go to this, one more thing with the election, like I was explaining a little bit earlier, we hold the election, the employees come vote, drop the ballots in the box. Right after that, after the polling sessions are over, all the parties come back and the board agent opens up that cardboard box, counts those ballots right in front of you, and you have a result immediately. There's a tally of ballots that's filled out. It's a simple majority wins. The tally of ballots is prepared by the board agent, and it's pretty straightforward. But that's what kind of concludes the election, and prior to any post-election proceedings. But that all happens right at the day of the election. Post-election, filing objections. So objections is usually based on conduct that one of the parties is engaged in that could have interfered with the laboratory conditions of the election. Usually there would be conduct occurring during what's called the critical period, which is between the filing of the petition and the date of the election. These objections must be filed within 5 business days after the election and accompanied by a written offer of proof. Both of those need to be provided, and the objections, the offer of proof is, like I mentioned before, is pretty much witnesses, identifying witnesses and what they would testify to with regards to the objectionable conduct. Hence, that is not provided to the other party, but the objections themselves are. There'll be a hearing if it's not something that can be easily fixed or resolved. We're going to go to hearing, and the rules and regulations state that it'll be 21 calendar days, so 15 business days after the preparation of the tally of ballots. So we try to stick with that, again, trying to get things as quickly as possible. I mean, that's in a nutshell the processing of a petition. I know that there's a lot of other things that can come up during the processing of the petition. I mean, we said, that's kind of the procedures behind it. Alan and Edgardo are going to be talking more about kind of, what's going on the day-to-day on the front lines of what you're working with. But what I do want to mention here lastly is blocking charges. You have unfair labor practice charges that are filed or are under investigation during the processing of an R case will not delay the election. This blocking rule went into effect about 13 months ago. Whereas prior to that, blocking charges would basically shut down the R case until the ULP allegations were resolved. But now, the blocking charges, even with the request to block that's filed, the instructions are to continue on with the representation case, continue on with an election. The question will be whether at that election, whether the ballots will be counted or whether they'll be impounded. And that's dependent upon the nature of the unfair labor practice charges. But that's something that, a significant change in, processing of the R case in the elections. So, there could ultimately, if it's impounded, then you have to wait to see what the unfair labor practice charges result is, whether it's merit or non-merit, and the regional director will ultimately have discretion on the impact that it could have on the election, it could say open and count them, or it could say throw out those ballots because the allegations had merit and interfered with the election. So there are a lot of different things, and that's still kind of evolving since it's 13 months ago. It's still fairly new and hasn't been applied a whole lot yet, but regional directors will have a say on how these charges impact the R cases. That's all I have for the procedures. Like I said, those documents should be in your packet, that the PowerPoint, as well as some of the blank charges and those documents that are referred to in there. But the procedure, people often ask, how quickly do you get to an election? And again, since this rule, the newest rule went into effect about 16 months ago, we've been in a pandemic. So it's hard to say exactly what the time frame is from, filing, because it used to be way back when it was like 38 days. And then when the 2015 rules came into play, the average filing to election was about 22 days, I believe. But now with these new rules and the extended period between filing and the hearing date, it's in the pandemic where we're directing a lot of mail ballots. It's hard to really kind of pinpoint exactly where we're at with respect to the median filing to election dates. But again, the rule does call, and we try to do the best we can in getting to an election as soon as practicable. So that's, I'll be around and taking some questions, but at this point, I'll turn it back over to Alan. Yep, you're on mute.
You're muted.
Yeah, thank you very much, Dan. I'm now unmuted. But I do want to make my hats off to the agency, to the board, to Chicago Region, especially to Dan and his crew. Both attorneys and field examiners at the board handle the election cases. I have found them, as well as agents throughout the country, very open, very transparent, very willing to help and answer questions and guide us through the processes. And if we don't understand a regulation, they are there to give us some thoughts, give us some direction. So it has been very good. You also remind me of the election time itself. And you're right about the old-fashioned metal voting booth and the box and how that operates. And it really is a marvel of American democracy, if I can wax poetic at a moment, because you have real people really voting in your site as a board agent, and you see democracy in action. So it really is something to be very proud of as an American, to have secret ballot voting. And it was a real foundation of the law when it was passed back in the 1930s. So I thank you very much, Dan. Now I'm going to share my screen. Oh, excuse me, better do it a different way. And we'll see if my screen is shared.
Alan, we don't see it yet.
All right, well, hold on.
Slide presentation.
Right. Oh, I have a circle moving. Oh, here. All right, so Drew, what should I do here, you think?
So Alan, are you in the Zoom application? Is that where,
Oh, hold on.
where you're at?
You know, it says to close the program.
All right, you don't want to do that. You'll
No,
want to
exactly.
you'll want to click the green screen share button, and that'll pop up a dialog box.
Right. No, I did do that. Got the dialog box, and now it's just circling. And let's see what I can do.
Yeah, it's frozen.
Yeah, it's froze. I don't want to X out because that will close the program, right, Drew?
Yeah, it will. You know, it will probably respond momentarily. So if you want to get started without your slides.
Yeah, I will.
Okay.
Let me talk about the lawyer's role. And I assume you see my face and not the box. The lawyer's role is really very interesting, and it's interesting from both the union lawyer perspective and the company perspective. There are 3 times when lawyers are playing a very important role. Certainly what Dan has talked about at the board is very important. And obviously the obligation, the ethical obligation, is to represent your client zealously. Although it is a fact-finding procedure, you still are representing your client and trying to get the client's obligations or the client's viewpoints across to protect the client and to help the client. But there's a lot that lawyers do before the petition is filed. One, to prevent the filing of a petition, and also to figure out what type of petition should be filed. If you're a union lawyer, you are thinking about filing the petition to have an election, the RC election. But if you are a lawyer representing management, you are thinking of 2 different things. You're thinking of, if the company wants to, or if the employees want to, giving them a voice to decide whether or not they want to continue having the union represent them. And there's basically 2 ways that proceeds. One is through RD, which is a decertification petition. And the second way is called an RM petition. An RM petition is a way for employees to decertify the union, but it's a petition filed by the company. Now, Dan was very interesting talking about service, a process. It's very difficult for employees to understand the procedures at the labor board and to figure out how to serve petitions on the company and the union and do it properly. And it's a real burden. And we've had employees call the labor board. There's an information officer who will guide them through it, but it's still very difficult. And so many times companies will then turn to the RM petition, and the company will file the RM petition to take to the board the issue of, do the employees want to be represented by the union? As I said, during the petition, there's the possibility of the role of the lawyer is very critical for both the union and the company. And then after the petition, after the election, it's very important for every lawyer, whether union or management, to conduct an after-action assessment. Just like in the military, figure out what happened. Why wasn't that hill taken? What happened? How can we improve? What can we do? So that's going to be very important. In many ways, the lawyer is a project manager, not just a lawyer spouting law, not just in court being a litigator, but pretty much a project manager, managing all of the different moving parts. In many ways, the lawyer is expected to be a know-it-all. We have to know every single NLRB rule, every single regulation. and all the details. I'm constantly having to refresh. I see my thing came up. Are you able to see that now, Drew?
That looks good, Alan. We're on your project manager slide now.
Yeah.
Okay, great. I see.
Alan, if you could let me know, I just put that up there because I have a copy of it. So I put that there.
Okay, great. No, I appreciate that. I still have the circle going. But anyhow, the lawyer has to be the know-it-all. Every single regulation, and as I was telling Dan before for the program today, I have to go back and refresh my memory, especially when it comes to mail balloting, all the different details. It's also very important to know all the precedents of the labor board because before the petition is filed, during the election, the client will be asking you questions, whether it's the union or the company. Can we do this? Can we do that? Can we say this? Can we give Christmas turkeys out? We've given Christmas turkeys out every year, and now it's Christmas time and there's a petition. Can we send out that Christmas turkey? We have to know every single law, every single precedent, because we don't know what's going to come up. But what's also interesting is we have to understand about the client. We really need to know that client. Let's say it's a manufacturing facility. Well, how is it organized? Is there production, maintenance, quality control, quality assurance? What happens with all the different employees? Are there clerical employees in the plant clericals versus the office clericals? We need to know how the entire company is set up. We also need to know if the union wins the election, there's going to be a union contract, a collective bargaining agreement. And who does the company want to have represented by that union? Does the company want to have the quality control people represented by the union? I had a case in Upper Michigan last year where the union asked to represent the production and maintenance employees, but not the quality control employees. Well, quality control is a very important function of a company, and the company wanted to have control over hiring and firing of those QC employees. They did not want them in the union. So we were very happy then to exclude the quality control employees from the unit description. What's really important, and one of the major mistakes that lawyers make and that companies make, is they want to have the most appropriate unit decided by the government, and that's not the rule. The rule, as I say here, is an appropriate unit. And it's the union that decides what, from at the first stage, it's the union that decides what is an appropriate unit. And that unit is then looked at by the parties, looked at by the company, and decided, is that an appropriate unit? Or is there a more appropriate unit? And is that larger unit an appropriate unit? Is that smaller unit that the union agreed to, is that not an appropriate? That's what creates the hearing. And that's something that has to be decided immediately. So the more you know about the company going into this issue, the better you will be as a lawyer, the better your client will be. So it's time now, before a petition is filed, before there's union activity, to really get to know your client, to really go to the factory, take a plant tour, get an organizational chart, and know what's going on. Also, you need to know who the supervisors are. Under Section 211 of the Act, supervisors are excluded automatically. But what is a supervisor? There are many companies that have people that are called leads or foremen, working foremen. Are they supervisors or not? Does the company want them in the union contract? Or does the company want freedom to hire and fire, demote, promote, decide their wages? These are important questions. The other question is, do we want the leads to vote? Maybe we want them to vote because their loyalty is towards the company and they will be a no vote. So this all is very strategic. If you can move on to the next slide, please. So we are managing all these moving parts. We're not just an advocate and litigator at the board deciding what is the appropriate or what is an appropriate unit, who is a supervisor and who is not a supervisor, but we are also managing the campaign. So one of the very first things we do as a lawyer is we ask the company, do you want to have a consultant come and help you? Lawyers should not be talking one-on-one to the employees. Lawyers should not be walking around the facility talking to employees. And there's many laws and reasons for that. Most importantly, there's a requirement under federal law that if you spend money as a persuader, you have to report that to the government. And the company has to report what they spend on a persuader to the government. So in many ways, the lawyer is a strategist, is the person behind the scenes and helping the company, helping the consultant run the anti-union campaign. The union lawyer is also a consultant and is also a tactician, figuring out what is good and what is bad, what should be done, what should not be done, what are the tactics that should be followed. So for example, you'll be hearing from Ed Villanueva. In a campaign we had 4 or 5 years ago, the union decided to put up pictures of Ed, if you remember, pictures of Ed in the driveway, and that he was the hired nasty person fighting the union. And so that was a very interesting tactic by the union lawyer. Lawyers also have to be soothsayers, and we have to hold hands of the company. And we can't overpromise that the company is going to win or that the union is going to win. And in that way, we are also social workers and psychologists. So next slide, please. From the union perspective, there's a whole pre-petition campaign that takes place at the company. And the union lawyer may well be involved in doing this, although most of the work is done by the union business agent and by an in-house organizing committee or employees at the committee who want to have the union. And the union lawyer will come in a little bit later on. But what's happening during this period of time is that the union organizers are collecting names and addresses of the employees, but most importantly, they're trying to figure out what the issues are. My rubric or my statement to my clients is an issue-free workplace is a union-free workplace. So what the unions are doing, what the union lawyer are doing, is trying to figure out what are the issues, because it's those issues that make a campaign. And there's many questions that have to be answered during this process. If we turn to the next slide, you'll see really what's going on here. And the next slide is really the next slide is really what the solution is that the company wants. Hold on for one moment.
I heard you were having technical issues or something?
Yes. So I'm trying to get the slide here come up, and it won't.
Okay.
But we could just proceed without it. It's okay.
Okay.
All right, thank you. Sorry for the interruption. All right, what's here, this is the authorization card. This is a legal document, and this is what's signed by the employees. And it gives the union the authorization to go to the labor board and to file a petition. As Dan said, the union needs 30% or more of these cards signed for the showing of interest. The next slide, please. What also is happening is all these things are being done underwater. I call it the Titanic of America. And it's swimming along, it's going along the ocean without a care in the world, and it hits the iceberg because all this has gone on underneath the water. The traditional union activity is filing the petition, or when the company gets word that there's a union meeting down at the local bar, or when supervisors will see that union authorization card on the floor of a locker room. Then the company knows that something's going on and they have to react. So what the company is doing, next slide please, and what the company lawyer is doing early on, even today, even when you don't think there's going to be a union, you are doing a vulnerability analysis. You are making rules on whether or not there should be strangers on the property. You are helping clients determine whether or not employees have the right to solicit or distribute materials during working time or not during non-working time. Are Girl Scout cookies purchased during working time? Well, if that's done during working time, then union authorization cards can be collected during working time. So these policies are very important. That starts the very day that a company goes into existence. Many questions will come up whether or not employees can make lists of other employees' names and addresses. Suddenly, I will get a call from a company manager. The employees are talking about their wages. We want to stop them from talking about their wages. Well, that's a violation of law. Employees have the right to talk about their wages. They have the right to complain about their supervisors. They have a right to compare their wages and benefits to the wages and benefits of other employees. So it's the lawyer for the company that is organizing what's going on at the company to making sure that the company is not vulnerable to a union organizing drive. Next slide, please. But what we're also doing is we are being proactive. During the COVID pandemic, it's been very common for groups of employees, non-union groups of employees, to start complaining about social distancing or the lack of social distancing, complaining about the lack of masks, complaining about people who are not vaccinated, complaining about having to be vaccinated. This can be protected activity. Protected concerted activity by non-union employees is protected by the government. So if you're terminating employees who are complaining about their working conditions, about getting vaccinated, that may well be a violation of the National Labor Relations Act, even if it's before a petition for a union is signed. We are also determining whether or not the company or the union here is vulnerable to a decertification petition. That takes time. It takes time for a consultant to come in or for the supervisors to be trained by a lawyer or by human resources, by the training department, for example, at a large company, or by the lawyer to figure out what is the vulnerability of the union. Are the employees happy with the union? What have been the issues with the union representation? And the union lawyer is also probably talking with the union business agent. What is the union doing? Are you shoring up the support of the union? Because there's a period of time, it's called a window period, in which these petitions can be filed. And we have to use these laws to the benefit of the company or the union for these petitions. Next slide, please. So the petition is filed, and this is done by the union business agent and sometimes by the union lawyer. The timing is very important, as I said, during the window period. You have to have the correct name of the employer. Is it Kaplan Enterprises or Kaplan Inc. or Kaplan Installation or Kaplan Rug Sales Company? What is the employer? And does that employer have those production and maintenance workers that the union has asked for in the petition? Maybe it's not Kaplan Rug Installation Company that has production and maintenance employees. It's the Kaplan Enterprises that makes the rugs. The showing of interest is important. As I mentioned here, 30% for the union to file the petition. Many times what we have found is that unions will not, we believe, unions are filing petitions when they have 80 or 90% of the authorization cards signed. So going into this process, it's an uphill battle. What's important for the RM petition, these are the petitions filed by companies to have the employees decide whether or not they want to have the union represent them. The test is the employer's good faith, reasonable uncertainty of the union's continued majority status. That means that we as the company need to present affidavits to the board, to someone like Dan, who will look at those affidavits signed by supervisors in which we provide good faith uncertainty that employees no longer want to be represented by the union. This is a real skill, I'll say, in understanding how to draft these affidavits and how to present this evidence to the board, to people like Dan and his colleagues. So we have to have these things done properly, and this is really the most important thing that lawyers do. Next slide, please. Once the petition is filed and until the date of the election, the Labor Board calls it a critical period for laboratory conditions. So it's like a scientific experiment, if I can be. It's like a pharmaceutical manufacturing facility where everyone is wearing white coats, and it's a sealed environment. So everything that's done by the company, by the union, by the employees, by the supervisors is going to be under the microscope. Has to be carefully thought out before it's done. So for example, I had a case of a company where there were a lot of female employees and male employees sitting at sewing machines. Well, the company decided, gee, those employees have been complaining for a long time about their chairs that they're sitting on for 8 hours a day. Let's give them new chairs. Well, a petition was already filed. Can we give them new chairs? It's a very interesting legal question. Certainly giving them a benefit during this critical period of time may lead to what Dan called objectionable conduct, conduct that causes the election to be overturned. And the last thing a lawyer wants, or the company wants, or the union wants, is to have the election to be rerun. Also, as Dan said, the details of the election are very important. Again, you need to know about the company, and the union lawyer needs to know about the company. When are the paychecks given out? Yes, they're given out electronically these days, but usually on a Friday or a Wednesday. That's usually when you want to have the election, is when the payroll is passed out. When do you want to have it? When are the shift changes? You need to know about the company. The union lawyer needs to know about the shift changes and how many employees are on each shift, how long those voting periods should take place. So this all has to be decided, as Dan said, within the first couple of weeks, because that goes into the stipulated election agreement between the union and the company. And these are all the details. Now, if there's going to be a mail ballot election, that all has to be figured out as well. And whether or not the election can be done in person or by mail. And this is very much in the discretion of the regional director. But I have litigated that issue before a regional director, where the company went to extra special efforts to make sure during the pandemic that there would be social distancing and where the place of the election would be in a special location. But even there, the regional director decided to have a mail ballot election. But it was worth fighting for, because the part of the strategy then is that we were protecting the employees. And so the employees then saw, as part of the tactics of the campaign, that the company was on their side to protect them. And then we agreed to the mail ballot election. And then the consultant was able to say, see, we agreed to the mail ballot election because that'll be even more protective of the employees. So that's what happens during the period for part of the campaign. Next slide, please. So we are also educating the employees. We're educating the employees about what's going on. And what's important is Section 8C. Section 8C is freedom of speech for the company. And the company, as many people have said, as many politicians have said, the company has a lot of power because the employees are a captive audience. They are in the facility and the company can talk to them at any time. Now, of course, balancing that, of course, is that the union can go visit the employees' homes at any time during the weekend or at night and make their pitch to support the union. The union will promise, we will change things. We promise to get rid of that supervisor. We promise to give you $1 an hour increase. What the employer says is that the union promises, but only the employer delivers. Section 8C allows the union to be, and excuse me if you represent unions, the foe of the company. Supervisors have the absolute right to talk about facts, opinions, and experiences. And that's part of the training that the consultant and that the lawyers for the companies give to the supervisors. And we take supervisors through Role playing. What are the facts? What are your experiences? Your uncle was in a union back in the 1950s. What happened with her? Was she laid off? Did the union protect her job? Or did the union protect her job because of seniority? Did your uncle have super seniority as a steward and the union protected him? Or did he not have super seniority and those stewards had the protection? So facts, opinions, and experiences. It all comes down in many ways to who can you trust. So these are the critical periods. Next slide, please. We want to avoid violations, and those are tips: threats, interrogations, promises, and surveillance. So it's very important to control the employees and to supervisors to make sure they don't do those things. Next slide, please. Again, we are there to persuade the employees to help the company proceed. There's a 25th hour speech that Ed will talk about, but campaigning can continue during the 24 hours before the election, or even during the period of time that the mail ballots are out, but done with great caution, with great advice from lawyers. Next slide, please. Then the election takes place, and in 30 seconds, I'll tell you the funny story. In Chicago, the infamous and totally bogus objections to the election filed by a union that lost filed by the company that lost the election. Turns out that the board agent showed up with the ballot box and the box and the large metal ballot voting, and the union business agent felt sorry for the board agent to carry all that, so helped the board agent carry it into the voting booth. The company won the the company lost the election, filed objections to board agent misconduct. How dare that board agent have the union agent touch the voting booth? That obviously, question mark, affected the results of the election. So you see how everything is very careful. If the union wins, the company has to address the issues. If the union loses, the company has to address the issue. It's kind of like what Bill Clinton said back in 1993, the campaign continues. The campaign always continues, because we want to make sure, not only from the union perspective, but from the company perspective, that the employee's choice is tantamount, that we are resolving issues. And really, from an employer standpoint, an issue-free workplace is a workplace where there's productivity, where there's logistics that are happening, where the trucks are not waiting on the loading dock to be loaded because material is going through the assembly lines properly, and where the maintenance people are fixing the assembly lines in the Amazon facility, for example, so that the product can be delivered within 24 hours. So next slide, please. So we have to recognize the importance of the process. We have to comply with every single law, all the details. We really need to learn the substantive law. We really need not to shoot from the hip. As I was working with a client in Southern Illinois, their corporate lawyer thought he knew everything, and he did not know anything. And so it was a struggle to work with the corporate lawyer who had his own ideas and his own knowledge, question mark, of the labor law. You really are, as a lawyer, whether union or management, a project manager. So thank you very much. I'm now going to introduce you to Ed Villanueva. Hopefully, my slides are not working, but Drew, can you bring up Ed's slides at all?
Yep, I'll have them up momentarily.
Okay, great. So Ed, I have worked with Ed Villanueva for about 15 years. He is a consultant who works with companies, and I now turn the program over to Ed. Ed, take it away.
Okay, well, thank you, Alan. For me, this is obviously a very unique experience, and certainly one that I welcome as a non-lawyer, but as a person who has been around this business for quite a while. So I'll just jump into it and introduce more about my company and talk a little bit about, well, more about, what I do, what the role of, somewhere along the line, somebody came up with the term persuader. And I like that better than some of the names that unions have called me over the years, for sure. But anyway, so let's get going. The presentation, we're having a little technical issue. It was going to be more animated, if you will, but so be it, as long as everybody can see it. The title of my presentation is Legally and Effectively Confronting a Union. I'll tell them, okay, I'm getting some instructions here. I apologize. Okay, legally and effectively, confronting, if you will, a union organizing drive. And in my case, it's going to be a discussion of those challenges from what I refer to as a boots on the ground perspective. As Alan has indicated, it's rare, hardly ever, that an attorney will choose to, participate in direct meetings with the voters, et cetera. And so the boots on the ground, face-to-face perspective that I approach these challenges with is what I'll bring here to this conversation. Okay, let's move on. Click on the next one, please. Okay, just quickly to share with you, my company, EMSI, Effective Management Systems International, been around for more than 3 decades. I like to say that more than the actual years. It makes me sound a little younger. But, we bring, obviously, a experience, frontline, hands-on experience keeping companies union-free. Listening to the 2 previous speakers, just kept flashing in my mind all of the experiences, that relate to everything they said from a legal perspective that I've seen in terms of actually, the role that we play. And I'll go for more into that. Okay, next slide, please. Okay, next. These were going to come up one at a time, but just look at them all, okay? You recognize all these symbols, all the unions, well, not all, obviously, but quite a few that everybody has heard of, steel workers and sheet metal workers and food and commercial workers union and so forth. And in the center of the slide, you can see, we've seen them all. And frankly, we've beaten them all. We've had elections against these representing companies and have had victories with these and so many others. By the way, there's a kind of a new breed of quote unquote unions that exist nowadays that are not really unions. They're almost like social worker agency scenarios, but they're backed by unions. Okay, these are some of the more common ones. Next slide, please. Okay, let's talk about, to coin a phrase that we're all familiar with these days, the root causes of unions. What's everybody think, that bring people to the point of saying, I don't like my company, I'm going to go to battle against them. Okay. Money, of course, everybody, we're going to get more money. Benefits, of course, is another cause. Or some form of revenge, I don't like my supervisor, or they did this to me several weeks ago or several months ago, etc. Okay. And then, of course, there's 3 very common expressions that are found in every campaign on behalf of the union. Respect. With a union, you have respect, dignity, or even more, let's say, I think falsely, a voice in the workplace. Now, why do I say that? Not to be aggressive, but just frankly, what is the process of getting a union? You have a representative. So we tell employees, we say, you're actually going to have less of a direct voice. You can't go to your supervisor, your boss, and ask for a raise and on and on. But these are some of the key things. Next slide, please. Now, I have, over the years, compiled what I refer to as the top 10 reasons that I've seen from a worker's perspective as to why people turn to unions, okay? Number 10, policies, attendance policies or discipline policies or whatever policies, etc. If you make changes to them, or if they're not understood, or maybe not published in a bilingual format so people understand them, that's something that kind of confusion could be one of the reasons people say, well, we need a union, okay? Poor communications, obviously. I've had it told to me by many, many employees, we talk to management. We tried. We sent them a letter. We issued, a whole bunch of us issued a demand letter, et cetera, a few months ago. They blew us off. Guess who's not going to blow them off, at least in terms of listening? That would be the union. Obviously, poor supervisors. You have to go to work every day with a guy or a lady or whatever that is not treating you nice, or doesn't listen, or hasn't processed your vacation request, or any number of things. Supervisors or managers in their interface, that certainly is a very strong drive. Discipline issues, of course. God, they punished me, they suspended me, but they don't do it with everybody else. The other guy, they let him slide. No respect for seniority. Now, this is seniority is obviously a term found in union contracts and on and on. And so many companies don't even like to say the word. Call it whatever. Call it service credit. Call it whatever. But I've seen many employees who have told me, I've been here 10 years, and so-and-so has only been here a year and a half, is already making the same as I am, or, my seniority, my service credit doesn't gain me anything. A union will take care of that. Benefits, the cost of insurance or understanding benefits. Quick synopsis, one company included in their benefit package a dog or a pest insurance package, okay? Pest insurance. I'd never seen that. But yet none of the employees really knew that was part of their benefits, right? So we obviously communicated it to them in the course of the campaign. The issue of wage parity, not so much how much they get paid, but, is it being fair? Nowadays, we're seeing lower paid classifications of people getting automatic raises because the fight for $15 or $15 an hour or whatever. Well, what about the guys that are already making 15 or 16? What's going to happen to them when are you going to give them a raise also, et cetera? So they'll see that as parity. Okay, obviously, number 3 is people want more money. So do I. So does everybody. Any kind of takeaways, number 2, is certainly the motivating drive for people to say, well, if the union was here, we would not have had this taken away. Whatever it is, it could be, we had a case of a lowering of the on-call pay of workers who were on call. It was lowered. That was a takeaway. Why do that? Okay, and last but not least, I think that the number 1 reason I've heard a lot is the expression, if you don't like it, there's a door. I've had hundreds of employees tell me, this company, if we complain, if we point something out, whatever, they want us to talk to them, they don't want to, but they'll say, hey, man, that's the way it is. You don't like it? There's the door. Okay, let's move on. I don't want to get too far behind. Next one, please. Okay, here's a typical process, if you will, that I see, and it's a couple of points are repetitive to like what Alan's already explained, but from my perspective, okay, the first thing is that petition arrives and everybody goes into panic and they go into denial. No way, this is not happening here. But the worst thing, and this is from the lawyer's perspective too, is immediately the management starts asking questions. Who's doing this? Who wants this? Are you in favor of this? In other words, ULPs are violated repeatedly. I know when I come on the scene, I already know, oh my goodness, you said that or you did that already, whatever. Okay. Step 2 is for the lawyer. Hopefully the company calls an attorney. They don't try to handle it themselves. Or I had one company that had a PI attorney. No disrespect to PI attorneys, but knew nothing about labor. But that was their attorney. Okay. Anyway, I think it was the brother-in-law of the owner or something. The bottom line is they hire an attorney, strategies, paperwork, legal stuff, and then they got to make a decision, right? How are they going to do this? I know some of my competitor companies out there, consultants sell videotapes or this or packages. One sold the campaign in a box scenario, etc. Okay. Or do they actually bring in a professional consultant persuader to be part of the what I explained in step 3, part of that 3-legged stool with management, the attorney, and the person who's going to be in front of the voters, i.e. the consultant. Next slide. Okay. Generally speaking, here's a campaign flow. You get the ball rolling in the first week. You're there, you're on site, you're doing things, management training on tips, right? Threats, interrogation, promise, buys, etc. And we start to kind of prepare sort of a campaign calendar based on the projected time, and you heard earlier the board timeframes now. I had a chance a few years ago to speak in front of the National Labor Relations Board in Washington, and I was asked to speak or participated in when they were talking about these quickie elections a few years back. And I told the 5-person board, I said, look, it's tough to sneak this stuff in and to educate people about something so complex in 20 days or whatever. You've got a business to run. Okay, so we get the ball rolling. Then step 2 would be obviously that first, what we call icebreaker meeting. It's, how are you going to do this? Clients ask me, how are you going to walk into a room? Why would they even want to talk to you and whatever? And, it works. People want to express themselves. So here I am coming into a room full of strangers, and I'm a stranger. Prior to that, would probably issue a memo or something. Bottom line is that, that first icebreaker meeting is going to set the tone for how we're going to interface with these people. I obviously try not to insult them or this or that, but I just tell them, hey, it's much more than you think or much more than you've been told. So give me 3 or 4, 45-minute to an hour sessions between now and the election day, and I'll try to, inform you of what the reality is if you in fact choose to bring in a union. Okay. The next couple of weeks or so, we're obviously continuing with more captive audience meetings and assessing and reassessing how the campaign is flowing. Is so-and-so, who we thought was a strong pro-union guy, is he all of a sudden, changing his mind in the meetings, the way he's expressing, or the reverse, etc. Towards the end of the campaign, obviously, we're looking at what is commonly referred the 24-hour period. We can't campaign or have meetings during the final 24. So some people call it the 25th hour meeting. And I typically try to get the top guy of the company. I've had people, literally, people fly in from Japan, the COO. I've had the president of Gallo Winery fly in on a helicopter to give his 24-hour speech. So the top guy, because now they're talking serious, and they've been hearing stuff along the way. And of course, the last part, and Alan mentioned, we can't campaign during that final 24-hour period, but we have an advantage. We can one-on-one talk to people if people have more questions, et cetera, during that period without holding meetings. Okay, next slide. Just want to point out, okay, direct interface, okay, the ability to directly be in front of these people is, the main contribution that I bring to the party. Okay, the legal stuff and so forth, clearly, that's why we got lawyers and the government's there to monitor things. Okay, but the ability to talk to these future voters and say, here's what you need to know before you actually cast that ballot. You may have heard some really nice sounding things from the union, but let's talk about collective bargaining. Let's talk about what, et cetera. Okay, the next slide. Oh, by the way, by having that intelligence, if you will, or interface, yeah, that allows for making better legal decisions, or even strategic decisions, obviously, as we go forward. Next slide, please. Okay, the consultant strategies, et cetera, okay? The main thing, obviously, oops, no, go back to the previous, please. Yeah, there you go, okay. So the main thing, of course, the left column points out is my ability to get in front of the voters, literally, okay? And there is some strategic things to consider. We'll talk about that too, is how you have the meetings and on and on. What are some of the tools we have to use? We use the facts, the union's own financial records on LM2 reports, their constitution and bylaws, and several things in there that employees will never see, and yet they need to see so that they know what they're getting into. We'll also, of course, use modern day, if you will, social media values. We've created YouTube channels for campaigns, Facebook pages directly for the campaign, so everybody can give their feedback, and on and on and on. Okay, and lastly, of course, is the consultant being on site is also, and we're typically there much more than the lawyer is, literally full days. Okay, and the point is that we're there to monitor too, because see, business is running, business as usual, we say. Yeah, but with a little several qualifications. And I've seen companies make decisions, right in the middle of a campaign that I've put an immediate stop to. I said, no, don't do that right now. You don't need to do that right now, or handle it the other way or whatever, because let's face it, they're just not informed about the process, and they've never been through it. Most companies that I've talked to, I tell them, I say, look, this is your first campaign. Hopefully it's your last. I really scratch my head when I would walk in and some cocky manager or supervisor or HR person, says, I've been through a whole bunch of these union organizing campaigns. And I say, that's not a good resume to have that you've created. You're supposed to not have that. Okay, next slide. Okay, some basic points, right? All right. Arrange your meetings cohesively the way you feel. If you feel you got a whole bunch of union guys, pro-union guys, put them in a meeting together. If you feel you're people in the middle, etc. Okay, you can do that. Schedule your meetings so that it doesn't interfere with their, working time. Their breaks. Don't schedule them on overtime. People don't like that, and it's just creating a negative feeling as they walk into the meeting. Okay. We make the meetings mandatory. We tell employees, or the supervisor do anyway, hey, got to go to the meeting now. And it's a mandatory meeting. 99% of the people will go, okay? Especially if I've created I want to say a positive enough environment that it's, open communication. Okay, so we want to do that. However, you're going to have some resistance. And I've always told managers that, don't drag anybody in here kicking and screaming. If they don't want to come to our meeting, keep them out on the floor. Let them work. Okay, most people will. All right, the union will obviously put out material or handouts, and we have to respond to it, or sometimes critique it or even mock it, because some of it really is comical to some degree. We can ask targeted questions without interrogating, which of course is the I in tips. Okay, engage the group. I like to use PowerPoints, and I'll have one of the guys one person in the meeting say, "Hey, John, read what it says up there," and he'll read what I've got in my perfectly legal PowerPoint presentation, because it's been tested and they've never found anything wrong with it. Okay. So we asked have them read it. So if a pro-union guy is reading, the law says this, that, or that, and he reads it to the group, it's pretty hard for him to come back and say, oh, that doesn't apply here, or something like that. So engage them, appeal to their kind of common sense and so forth. I gotta hurry. Okay, let me ask you, union or no union? Are you, who has the final word on wages? The boss. Okay, now you've answered your question. Okay, we're going to move on. All material at the very bottom is run through the labor attorney consistently. We want to have attorney-client privilege and also the ability to obviously be sure that we're lawful. And we're pretty sure. Okay, next, please. I think I'm controlling it. Next, please. Okay, I think a handout that I gave you, something I came across. This is Amazon. It was a New York Times story. And I got to tell you, as you read that, I hope it was given to everybody. If you read through that, you got to figure Amazon has probably some of the top labor lawyers in the country, I'm sure, yet the mistakes that the company was making that are pointed out in this article really is, I think, a classic example. And the article itself was called "How Amazon Crushes Unions." Okay, next. Okay, what about decertification? Alan covered it a little bit already, but keeping a union out is one thing. Getting them out if you have it is another. And guess what? It is doable. Alan and I have worked on several cases, and I'll repeat a little bit of what he says, but let's move on, okay? In the case of decertification, as pointed out, 4 ways to get rid of them. Either the employees file an RD, they motivate themselves, they work through the system, etc., or something like, the withdrawal of recognition is achievable because if employees present the right evidence and the legal stuff works out, etc., that's one way. Or the union walks away sometimes, futility at the bargaining table. But the last one is really the key, RM. Okay, Alan and I have had many discussions, and with other, colleague attorneys also. Can we do this? Can we not? It's there. It's a legal process for management to say, you know what? I don't think we have the union representation anymore. So let's move on because I'm running out of my time. Okay, just remember this: even under the restrictive National Labor Relations Act, there's the premise. If an employee asks you a question, they deserve an answer, as long as it's not unlawful. Okay, next. Okay, some of the key factors, you can kind of see them. I'm going to just quickly, okay? You got to be aware of the critical, that window period, start early, 3 to 6 months ahead of the window period. Consider doing a survey, an anonymous employee opinion survey. Not talking about the union, but I'm telling you, it has happened. People will write in their answers and say, the problem with this company is that the union people did whatever. Okay. It stimulates an anonymous approach to see what the employees are feeling. Okay. Certainly upper management needs to continuously communicate. If you're 3 to 6 months away from your contract negotiation starting, write your employees a letter. Be sure it's lawful, but write them and say, hey, why not? I'm concerned about how we're going to do. We had a tough year. COVID hit us hard, et cetera. Okay? People will start to ask questions as a response to that. Okay, negotiations, meet with anti-union committees. Anti-union sounds horrible, but employees will say, hey, me and 3 or 4 other guys, we don't think we want to talk to them, let them know about their rights. The labor board prints out little booklets that says, that openly speaks about the fact that employees have a right to file an RD petition and on, but most of them don't know. The union will certainly come back strongly. They don't like getting kicked out of companies, and so be prepared to respond to the aggressive anti-union thing. You can anticipate ULPs. No, this is unfair. This is against the law. Sometimes, many times, just to try to aim toward the effort. But I'll tell you what, you have to be fully committed. A company says, I want to test to see if legally my employees want to get rid of this union because it's not up to the company. There's still going to be a vote. Got to be committed. Next slide, please. How do we get the ball rolling? They say, okay, you can't go out and ask people, hey, would you like to get rid of your union or anything of the kind? But, we communicate. We talk to the supervisors and just say, hey, what have you heard on the floor in reference to how people feel about the union? I can almost guarantee you that at some point somebody's going to say, well, yeah, there's 3 or 4 guys or so-and-so is constantly complaining to me about paying dues or on and on. Okay, these have been have happened already. Okay, so we want to know what the comments have been and on and on. But at the bottom of the slide, I point out we're looking for quote unquote magic words, and this is something that Alan and I have shared on many occasions. The magic word being any version, shall we say, of, is there anything we can do about this union? Or can we get rid of it? Or, anything to that specific. If employees are asking that question, you have a legal right to answer that question. Oh, well, as a matter of fact, here's the labor board brochure or something, read about it, and the different options that they have, okay? Kind of getting the ball rolling. Excuse me, next. I think we're coming, okay. Look for these two cases, okay, as in reference to decertifications. The Levitz case, and the citing is there, and it should be on your slides, okay? Basically, and I'm not a lawyer, but I can just tell you, the Levitz case opens up the door for questioning the union's, authority, representation. Do they still represent the majority? And again, those are, things to discuss very, very effectively. And the second one is El Cid. It's a case that is used during the RDs, especially because the union's counter is always going to be, you're going to lose this, you're going to lose the other, they're going to fire you, they're going to take away this, they're going to take the other. Well, the El Cid case gives us a chance to actually, the company, I should say, guarantee in writing and with signatures and letterhead, whatever, we're not going to take anything away. Can't promise you more. Can't promise, I can't threaten you to take anything away, but the Levitz case allows for that. Be glad to talk to you.
Yeah, El Cid, very good.
Yeah, okay. I'm sorry, El Cid. The second explanation was regarding El Cid. Thank you. Okay, I think we're coming up to the end. Let's go. Next. Okay, closing thought. I think most employees don't want conflict with their employer. Okay, most people come to work with the goal of doing that, going to work. Okay, workforces always fine. It's like a bell curve. 10 to 15% of the people will be pro-union when you walk in there. 10 to 15% will absolutely be anti-union. So it's that middle part of the bell curve that we need to, quote, persuade, right? And we don't even need all of those in order to secure a victory for the company or a loss for the union. The law, in my opinion, is actually much more favorable to companies. Why? Because we have access to these folks 8, 10, 12 hours a day, and have had so for years. And so the ability to use that effectively is what I think is the key here. Okay, for sure, we always say we got to be lawful, assertive in our campaigns, and creative. I'm proud to say that in my 35 years of being in front of hundreds of groups and tens of thousands of employees and blah, 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 I've never, ever been found guilty of committing an unfair labor practice in my campaign. So we're lawful, but we certainly are assertive with that. Okay, I think that's it. Let's move on.
Yeah, so I want to thank you, Ed, and I think you've said something very interesting about lawfulness. I remember talking to a lawyer who shall be unnamed, and he asked me, he said, will you violate the law to win an election for a company? And I looked at him square in the eye and I said, no, I will not knowingly violate the National Labor Relations Act, engage in objectionable conduct just to win an election. He looked at me, he said, well, then I don't want to associate with you. I would not want you to be my client's lawyer. Well, that's fine. That's fine. I mean, that lawyer can do what he wants. But I think that's malpractice. I think that's just wrong. Now, what do lawyers do? As being part of what a lawyer is we know the law, but we also know where the gray area is. We know where the line is, and we know how to go up to that line, but not knowingly cross it. We know how to work with our clients to make sure everything is lawful. So when that union lawyer recommends, and this happened in Scranton, Pennsylvania, when that union lawyer, I hope it wasn't the union lawyer, but when a dead rat, 3 feet long dead rat, appears on the driveway of a pro-company supporter, is that objectionable conduct that could lead to the overturning of the election. So that's what lawyers are really doing. I wanted to ask Dan what he thinks is the greatest mistake that he sees lawyers make.
Yeah, I mean, I guess the only thing is going back to procedures and everything. Like I say, I'll stay out of the debate as far as the anti-union campaigns and the union campaigns and everything. But when it comes to dealing with the agency, I think that the newfound statement of positions and responsive statement of positions, waiting to the last minute to submit those, because there's, we've had several that were submitted late and, really did alter the whole process of the negotiations and getting to a step, and really had a profound impact because they can't litigate it. So now it's kind of, puts you back in a corner if you don't respond to that. So I think that would be one thing, and just general transparency, working with the agent and being upfront with the agent, I think can really help the whole process.
Yeah, so let's talk about extensions of time. You do not like to give out extensions of time.
We don't. However, under the most recent rule from June 2020, that they went back to the reasonable amount of time, reasonable basis for granting an extension of time. So, but we usually, for hearings, and we usually don't like to grant more than a couple days, and for good reason shown.
Yeah, and I really see, as a litigator, because now I'm in private practice and there's a lot of litigation, some litigators tend to always get extensions of time. They're always going into court. They're contacting the other side for stipulated agreements on extensions of time. It's not the way it works at the Labor Board. Don't think you can play the system and play the other side with extensions of time. If it's due, it is due. And that's why I said early on that the focus changes. Once the petition is filed, the role of the lawyer really has to change. You're not just sitting back anymore. You are really managing this project minute to minute, day to day. You are making sure that every single deadline is met, that every single regulation is followed, so that you can protect your client, whether it's the union or the company, because you really need to know those regulations, really need to follow them. And that's why working with the board is so important. I worked for a lawyer once who would hang up on government agents. And I said, no, it's not hanging up on government agents, it's working with government agents that will help the client. So I do want to thank everyone for joining us today. I do apologize for the glitch in technology. I used to joke that I have a new disability called technology deficient disease, but I then found out that there is a disease called technology deficient disease. So I say that with respect. But from time to time, we do have technology issues. But I do thank you, Drew, for stepping in and saving the program. I thank you very much, Dan. Thank you, Ed, very much for your input. And I thank you all. We look forward to seeing you in December. Have a great day, everyone. Bye-bye.
This segment of the program has concluded. If you have any questions regarding the content of this presentation, please contact the presenters via the Submit a Question icon on the program landing page, or email ISBA directly at clespeakerq@isba.org. Be sure to include the topic and speaker. The speaker or another qualified attorney will answer your question as soon as possible.